Welcome to part 1 of patent research. In this episode, we will cover the basics of patents. What is a patent? Rights granted to inventors by the federal government pursuant to its power under Article 1, Section 8, Clause 8 of the U.S. Constitution that permit them to exclude others from making, using, or selling an invention for a definite or restricted period of time. Once a patent is granted, it is regarded as the personal property of the inventor. Inventors are not required to participate in the patent system. There are 3 types of patents, actually 4. 1, design patents, 2, plant patents, 3, utility patents, and 4, international patents. Article 1, Section 8 of the Constitution. The Congress shall have power to provide for the general welfare of the United States, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Governing laws. Patent law in the United States is based upon statutes located in Title 35 of the U.S. Code, including the Patent Act of 1952. The rules of the Patent and Trademark Office, found in Title 37 of the Code of Federal Regulations, provide additional authority. In addition, the General Agreement on Tariffs and Trade, or GATT, has led to significant changes in the U.S. patent law that are designed to bring some aspects of U.S. law into conformity with those of the country's trading partners. GATT. The General Agreement on Tariffs and Trade was negotiated during the UN Conference on Trade and Employment and was the outcome of the failure of negotiating government to create the International Trade Organization, or ITO. GATT was formed in 1949 and lasted until 1993, when it was replaced by the World Trade Organization, or WTO, in 1995. The original GATT text is still in effect under the WTO framework, subject to the modifications of GATT 1994. GATT was supposed to provide a level playing field among over 100 nations. In 1925, the Patent Office was transferred from the Department of Interior to the Department of Commerce. The basic structure of the current patent law is stemmed of the Patent Act of 1952, which amended the review criteria so the inventor had to describe not only the invention but also the basis for its infringement. Plus, the invention needed to be new, useful, and non-obvious to keep individuals from taking ownership or taking away from the base pool of knowledge in a peculiar field. After the regained enthusiasm for the intellectual monopoly, in 1982, the Court of Customs and Patent Appeals was abolished, and patent cases were heard in the newly established Court of Appeals for the Federal Circuit that provided more protection to patent owners. In 2011, the Leahy-Smith America Invents Act, or AIA, significantly changed the patent system from 1952, choosing between the first to invent and the first to file systems. The AIA adopted the first inventor to file requirement. Such provisions went into effect in 2013. A patent is like a legally protected monopoly over a specific intellectual property. Patents grant inventors the exclusive right to make, use, or sell their inventions for a period of 20 years. Patent holders can prevent anyone else from using their invention, even someone who innocently infringes on the patent holder's intellectual property rights, by subsequently developing the same invention independently. Alternatively, patent holders can require that subsequent users pay licensing fees, royalties, and other forms of compensation for the right to make commercial use of an invention. The patentability of inventions under U.S. law is determined by the Patent and Trademark Office, or USPTO, in the Department of Commerce. A patent application is judged on 4 criteria. The invention must be useful in a practical sense, novel, and non-obvious. The invention almost must be described in sufficient detail as to enable one skilled in the field to use it for stated purpose. In general, raw products of nature are not patentable. DNA products usually become patentable when they have been isolated, purified, or modified to produce a unique form not found in nature. The USPTO has 3 years to issue a patent. What is intellectual property? Intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. Intellectual property is protected in law by, for example, patents, copyright, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. The application for a patent is accompanied by an oath that the inventor believes himself or herself to be the first and original inventor. The patent laws of the United States do not discriminate on the basis of the citizenship of the inventor. An inventor from another country may apply for a patent on the same basis as a U.S. citizen. An application for an original patent must be accompanied by a filing fee payable to the Patent and Trademark Office. Fees vary depending upon the type of application and the size of the entity applying for the patent. Upon receipt of an application for a patent, the commissioner must examine it to determine whether the applicant is entitled to a patent. The Patent and Trademark Office is not restricted to the use of technical evidence in reviewing applications, but can act upon anything that establishes the facts with reasonable certainty. A patent application can be rejected for substantial and reasonable grounds. If the patent is rejected, the commissioner must notify the applicant of the rejection and the grounds for the rejection. An applicant can request a re-examination of the application and submit evidence to rebut the reasons for rejection. A pending application may be amended until the Patent and Trademark Office ultimately decides the matter, either by issuing the patent or rejecting the patent application. An amendment that involves a material departure from the invention described in the original specification or enlarges the scope of the original application is invalid. When made within a reasonable time, amendments relate back to the original date of the application and are treated as if they were included in the original application. This is significant because time determines who will be entitled to the patent when two inventors claim essentially the same invention. Statutory bar section. Under this rule, an inventor is not issued a patent if her invention was described in a book, catalog, magazine article, thesis, or trade publication in the United States or any other country before he or she invented it, or more than a year before he or she filed the patent application. This statutory bar applies regardless of who made the invention discussed in the prior publication. Thus, if an inventor publishes a description of an invention or places the invention for sale or for public use, a statutory bar can result. Once an invention is placed for sale in the United States, the inventor has just 1 year in which to file a patent application, or the right to patent that invention is lost forever. The clock begins when the invention is placed for sale, even if it is never actually sold. This rule is intended to guarantee that an inventor cannot expand the period of patent protection for more than the commercial exploitation of his/her monopoly. A monopoly is a market structure in which there is a single supplier of a product. It may be small or large, it must be the only supplier of the product, or sells a product for which there are no close substitutes. Monopolies are fairly common. For example, the U.S. Postal Service, local utility companies, local cable providers, and even your social media giants. Infringement is the unauthorized making, using, or selling for practical use or for profit an invention covered by a patent. Effective in 1996, GATT also made the offer to sell a patented invention without the permission of the patentee a direct infringement violation. Although no infringement can occur before a patent is issued, infringement can occur even if the infringer does not have any actual knowledge of the existence of a patent. A direct infringer is one who makes, uses, or sells the patented invention without permission from the patentee. An indirect infringer is one who actively encourages another to make, use, or sell a patented invention without permission. A contributory infringer is one who knowingly sells or supplies a part or component of the patented invention to another, unless the component is a staple article of commerce and is suitable for a substantial non-infringing use. The definition of an infringement has been greatly expanded in the late 1980s and 1990s. It is also an infringement to provide a substantial portion of the components of a patented invention to someone outside of the United States so that the components can be assembled outside of the reaches of U.S. patent law. Similarly, it is an infringement to import into the United States a product made by a process covered by a U.S. patent, although it was produced outside of the United States. Of patent research coming soon, where we will explore in greater details about governing law with patents and the changes that we need to make to patents. Thank you so much for watching. Please like, share, and subscribe.